Welcome to the first of 4 sessions in the 2022 SUBStrong Reading Between the Lines Contract Study Track. I am Mark Cohn with Delta Drywall in Denver, Colorado, and we are sponsoring the 4 sessions in this track. Delta Drywall was founded in 1969. We build mostly commercial buildings, which includes retail, schools, rec centers, office buildings, including TIs, medical office buildings, and hospitals. Our projects are built in accordance with the subcontract. The construction subcontract contract is the single most important document to the subcontractor business. The ASAC Attorneys Council is launching a 24-topic series contract study called Reading Between the Lines. 4 sessions will be offered today and tomorrow. Monthly sessions will continue throughout 2022. Attendees will earn a certificate of attendance showing that you are a champion of the construction contract. So let's get to it. Session 1, what's in the contract? A contract is an exchange of promises. One party makes one set of promises in exchange for promises made by the other party to the contract, whether it's called an agreement or a purchase order or a memorandum of understanding or anything else you like. An exchange of promises, such as a promise to provide work, materials, and or equipment in exchange for a promise of payment, is a contract. What's in the contract is presented by Amanda C. Hoberg, attorney with Woods Aitken. Amanda joined the Woods Aitken Denver office in 2020 and is a member of the firm's construction law and commercial litigation practice groups. Amanda has significant experience preparing and taking cases to trial. She is a proven advocate who assists and counsels clients through all stages of a dispute. Amanda, what's in the contract?
Thank you, Mark. I appreciate that and appreciate that introduction. And I'm going to go ahead and share my screen to make sure everyone's able to see that. And we'll go ahead and get started. All right. If anyone is not able to see that, will you just let me know so that I can try to fix that? All right, so I think we're ready to go. Let's see. All right, so we're going to start by just talking through the agenda for today, talking through what is a contract. And I think that that's actually a harder question to answer sometimes than we think. Sometimes we look at documents and it might say it's a contract, or someone might tell us it's a contract. And that's sometimes how we rely on what we consider the contract between us and another entity or another party to be. And sometimes I think it's worth just reminding ourselves that what is and isn't a contract is a question that we litigate in court all the time, because it isn't quite as simple as a document just saying that it's a contract, right? We really need to look back through and say, what were the promises exchanged? What was given up between the parties for this to happen? How was it executed? Was it executed? When was it executed? And so the fundamental question of what is the party's contract sometimes is a bit harder of a question to answer than I think we necessarily give credit for. So we'll start with how is a contract formed and going through just the basics of that. What's included in a contract? We could probably spend multiple days talking through each of the different provisions that are in a contract. And I think over the next 2 days, you'll probably get more detail about specific topics. But for now, we're just going to go through generally some of the topics that I think are particularly relevant to subcontractors and subcontract contracts. When we're talking about what's in a contract, I think it's really important to remind ourselves that it's more than just the words on the paper, right? I'm sure plenty of people here have run into an experience where they read the contract over and over again, and they get into a lawyer's office or a courtroom or a deposition, and suddenly something that seems clear as day on paper you're being told, well, that's not really what that means, or that's not how the law interprets that. And so I think reminding ourselves that sometimes the words in contracts get changed just by the nature of the law is something that we have to keep considering whenever we're looking at contracts and negotiating contracts. And then we'll just walk through a few common construction contract issues. Again, we could probably spend days talking about that, but we'll just walk through a few.
Amanda, excuse me.
Yeah.
We lost your screen. It's a blank screen.
Okay. Let's try this again.
You've clicked the screen at the bottom.
Yep.
The monitor.
Did that work?
There you are.
Okay. Tell me if you lose it when I click here. Are you supposed to see it?
Yes.
Okay. Sorry about that. All right. So we will just get right to it. So why contract? I think that it's important to start with, in theory, why we want to do this and why we think that entering into written agreements for construction projects matters and what our ultimate goals are in doing it. Obviously, this doesn't always pan out practically, and it doesn't always these goals of what we're doing don't always work. But at the end of the day, this is why we think this is a good process, right? We want to make progress predictable. So when we're entering into unpredictable situations, things that are going to happen in the future, contracts hopefully try to make a little bit of what's to come predictable, or at least let us know, hey, these are the potential risks that are coming. How would we hypothetically deal with them when it happens? So we want to try to bring predictability to an unpredictable situation. It helps us achieve strategic objectives, right? You guys have a much harder job than I do. You're out there every single day building things, making infrastructure happen, right? And that doesn't happen unless we team up and we have people from the different trades doing what they do best and what they've mastered and what they've become experts in. And so to create what you guys create every single day, in a lot of situations, that requires working with a team. And so when we have strategic objectives from a team, we obviously need a way that we're going to hold people accountable and also make that teamwork happen and function as efficiently as possible. Hopefully, our contracts are setting realistic expectations of all of the parties involved, right? So we are hoping that by writing these documents that people are able to understand what the expectations of the other parties are, and you're able to express your expectations to the people that you're teaming up with. This next one, we hope that we're assigning risk to the party best in the position to control the risk and provide the means to control the risk, right? So at its very heart, when we're contracting, we're recognizing risk. And it's not about getting rid of risk, because we're never going to be able to do that. It's just about allocating that risk. And in the best case scenario, when we're negotiating our contracts, we're trying to find the person who is in the best place to be able to handle that risk, and the most willing person who's going to say, I am able to take on that risk because I might have X, Y, and Z control mechanisms to deal with it. And I do that as a part of my business, right? Contracts can provide a framework for future negotiations. So You might think in this context of things like master service agreements, right? If you have a particular party that you work with all the time and you're just doing different projects for the same party, maybe you and that party can get to a place where you've negotiated some sort of master service agreement where you know how the two of you work together and you've talked about how you allocate risk. You've figured out processes that work really well for the two of you. And so you've created a framework of working as a team, and you're able to use that both for future negotiations and also for future projects. I think that's the same for the next one as well. It kind of solidifies our working relationship. I've always been told, and I've said multiple times, sometimes the hardest jobs we do is when we work with friends or family, right? And I think part of that can be because we leave a lot of things unsaid when we're working with people that are our friends or our family and we have a certain level of trust with, right? And so we don't always force ourselves to go through the process of putting down on paper and creating some sort of an agreement that's going to structure that relationship the same way we would if we were about to contract with a stranger or someone that we don't know anything about. And so in theory, what our contracts are doing are taking all of those unspoken assumptions and everything that we have in our heads and force us to articulate it to the other party. And so that's one goal of contracts, right? And then the other thing is we're trying to say, look, neither of us are legal experts and we're not planning to become legal experts. And if it's up to us, we'll keep the lawyers out of this, right? So through our contract, we're trying to make our own world, right? How are we going to operate? What's the law between the two of us? What are the punishments if I don't act a certain way? What are the expectations of my behavior? And so through our contracts, we're trying to create a little bit of a private law, if you want to put it that way, just so that we can operate within our own world to a certain extent. And so probably as I talk through each of those, you would each all have examples of when this has not happened, right? Through a contract for whatever reason. Something went wrong to where the private law got busted up and you were in a courtroom dealing with Colorado or federal law, right? So I'm not saying that this works all the time, but I think starting out, it's important to just reset your mind as to say, why am I contracting? What's the purpose of it? So let's move on to what is a contract? Because like I said, I don't think that this question is, as always, it's not as easy to answer as maybe we talk about it or in our common conversations, we say, oh, just hand me the contract. Let me take a look at the contract, right? Well, let's look at what a contract actually is. So for this, I'm going to take you back to law school. And in law school, Contracts 101, what we learn for contracts is that a contract has to have three things. It has to have an offer, it has to have acceptance of that offer, and there has to be consideration to which supports the acceptance of that offer. And so we learn it, or at least I did in law school, as an Oreo, right? Top of the Oreo is your offer, bottom is your acceptance, and what holds that offer and acceptance together is the cream filling of the Oreo. That's your consideration. And so one of the things when I'm trying to learn about concepts, legal concepts, or think about the future, one of the places that I would really encourage you and anyone on your team to look is Colorado's pattern civil jury instructions. These are available publicly. They're available online if you want to take a look at them. And basically, they explain legal concepts, any legal concept for the most part that you want to look at. And it tells you how the judge is going to tell the jury what that means. So at the end of the day, if you get into a dispute and you take it all the way to trial, these instructions say, here's how this judge is going to explain this concept to a jury. And so I like to look at them, and I encourage people to look at them because in theory, what we've done is we've taken legal concepts and we've put them into a way that we expect everyday people to be able to understand. And so throughout this presentation, I'll refer back to the pattern instructions. And I just would encourage you, if you are ever in a dispute, to take a look there, and it can help frame things up for you. So if we are going to take the idea of contract formation to a jury, the way that the pattern instructions tell us we're going to talk about formation is that we're going to say that a contract is formed when the offer is accepted without changes and or additions. And an acceptance is an expression by words or conduct by the person to whom the offer was made of agreement to the same terms stated in the offer, right? So when we're talking about contract formation and this idea of offer, acceptance, and consideration, one of the things that I think jumps off this page, especially in a negotiation standpoint, right, is that if an offer is going to be accepted, it has to be accepted without changes or additions. So if someone makes me an offer in a contract and I go through and redline a few different things, if those things are material terms to that contract, even if I sign the bottom and send it back to them, I haven't accepted the offer that was extended to me, right? I've accepted, or in a second, we'll talk about counter offers, but I haven't accepted that offer without changes and or additions. And so when you're thinking about this process of contract formation and contract negotiation, think about how this works in practice, right? Exchanging drafts back and forth, exchanging emails back and forth about what the terms of this contract might be. Just remember that if we're going to have a contract, that offer has to be accepted without changes and or additions. The other part I think about this slide that matters is that when we're talking about acceptance, a lot of the times emphasis gets put on signatures at the bottom of documents, right? But you don't have to be in construction very long to know that a lot of the times people end up accepting offers or agreeing to contracts, perhaps not by a signature at the bottom. But instead they get a contract, they're thinking about it, and the next thing you know, you get an email from the owner or the GC saying, hey, I need you out there tomorrow to start doing X, Y, and Z. And before you know it, before you've had time to ship this contract off maybe to your legal counsel or whoever within your company reviews it, you're out there starting work, right? And so sometimes when we get contracts and we go out and we start doing conduct that a jury or a judge might later consider acceptance, that's something that we really got to keep in mind, because at that point, the only document and the only terms is what's been sent to us, and we haven't sent back our counteroffer or our changes. So just remembering that it's not only about the signature, but sometimes it's also about your conduct when you're holding on to that document, whether you've signed it or not. The other thing the pattern jury instructions tell us, and I talked about this a little bit before, is just that in this contract formation process, one of the things that happens is that we end up getting counteroffers exchanged back and forth, right? So the jury would hear, if the person to whom an offer is made changes the offer in any way, that's a counteroffer. And unless that counteroffer is accepted, there's no contract. So this just goes back to what we were talking about before, that in order to have this offer and this acceptance, we can't make changes. We can't make additions, because otherwise, if those additions and changes are to material things in that contract, we don't have a contract. We don't have an agreement. We have a series of exchanges of counteroffers. And so just something to keep in mind during that negotiation process. Again, I talked about it. We learn it in law school as Oreos, right? And so the middle of that Oreo is what we're going to call the consideration. And if you've been through litigation before, you might have heard sometimes people attack contracts by saying, hey, there was no consideration for that promise. And you might see it again just in a lot of contracts. It says that the parties agree that there's consideration for this deal, right? But it doesn't always list it out. So what is consideration? When we're looking at it, and when if a jury was ever asked to look at it, what they're going to see is consideration is a benefit received or something given up as agreed upon between the parties. So a lot of the times consideration isn't an issue because money's changing hands. And so that's going to be a benefit that we receive, or it can always be something that we give up. But when we're thinking about consideration, just think that that's what keeps this deal together. I'm agreeing to give you something, you're agreeing to give me something. And because we're both doing that, or we're both giving something up, there's this thing that holds this agreement together. And that's legally what we consider consideration for a contract. One question we get a lot is, does a contract have to be in writing? And the answer is, to a certain extent, it depends on what the contract is for. There are certain things in Colorado and nationally that the contract will have to be a written contract. But I wanted to tell you that generally speaking, the answer to this question is no. And you can see here that we would actually instruct a jury in a lot of circumstances so that they would know that a contract doesn't have to be in writing. And so as the jury would hear, if written, it doesn't have to be signed by either party or dated. And a contract may be partly oral and partly in writing. So this is just something to keep in mind. Obviously, it's common practice, and we would always encourage you to put your contracts in writing so it's clear for 2, 3, 4 years down the road when you're in a dispute over these contracts. What were the terms? What were the agreement? But ultimately, and you've probably run into this before, our contracts don't have to be in writing. Sometimes our change orders and the change order process ends up this partial writing, partial oral type situation. And so that's just something to keep in mind as you are working through your contracts, and also as you're going through each project, that sometimes people will say there were changes or additional agreements that never got put down into writing, and those can be enforceable. So the other question that comes with this is, does the contract have to be signed to be enforceable? And again, the answer, generally speaking, is no. There are certain contracts that we do require by law to be signed by any party we're going to enforce it against. But keep in mind that the signature at the bottom of the page isn't the end of the analysis, right? We got to see, does it appear from the project documents, from the record of the project, that there was an agreement here to the essential terms of whatever this agreement was? Can we tell that through the way that you acted with the general contractor, the way that you acted when you were out there performing? And that's things that we can look at to say, hey, he might not, or she might not have signed this contract, but I can tell from the way that she acted that she knew that in order for notice to be given, it had to be mailed to this specific address, because on every instance, she mailed it to the specific address. So, hey, it doesn't matter that it's not signed. I know from her conduct that she knew what she was doing. And so there is an agreement here. So just keep that in mind. We see this come up quite a bit, particularly in this COVID world where everything was being done on the computer. People weren't getting together, contracts weren't being physically exchanged, anything like that. So we saw half signed contracts. And I think that that's pretty common these days. So if you don't have fully executed contract, which we'd always encourage you to do, just know that that's necessarily not going to get you out of it. I mentioned that there are some exceptions to this, and that is true. There are some statutory exceptions here in Colorado and nationally that are going to say, hey, for this contract to be enforceable, not only does it have to be in writing, but it does need to be signed by the party that you're trying to enforce it against. And you might hear the term statute of frauds that can be referred to. And this is really about making sure that certain contracts, our legislature has said certain contracts we really think need to be put in writing. And so there's certain things you'll see statutorily here. We have that if the agreement cannot be performed within 1 year after the making thereof, if it's for a sale of goods for the price of $500 or more, and then certain credit agreements as well. Our legislature has said these contracts need to be put in writing. And so you're going to want it in writing, and it's going to need to be signed by the party against whom it's being enforced. And so there's a long list of other statutes that I could go to that do require written contracts. But that's just something that you would want to kind of take it on an issue by issue basis, but just keep that in mind. So I thought just pausing there for a minute before we go further and just talking through some scenarios that we see come up quite often in terms of contract formation. So this is first scenario. We're talking about a sub issues a bid proposal contains scope clarifications and exclusions. So the sub's sending it back. GC issues a subcontract template. There's no scope clarifications and there's no exclusions that the sub requested, and then the sub commences their work. This is a situation that we see come up quite often. And so just looking back at what we've talked about so far, remember that even if you send back your clarifications and your exclusions, if those don't ever make it into the subcontract and you begin work, there's a question there, right? What is the contract at that point? Did you change material terms to that contract that didn't get accepted by the general contractor, yet you started work? Is that going to be seen as acceptance through your conduct of the subcontract template that you were given? And so obviously these issues as they play out in real life are much more complicated than, and there might not be the same answer to this depending on the set of facts that come forward. But this exchange of documents, this exchange of counteroffers can make it a real question of what is the contract? What did these parties actually agree to? And what does their conduct show that they actually agreed to? Another common scenario that we see is that a general contractor issues a subcontract template. The subcontractor marks up the subcontract with different red lines or changes. Sub starts work, and then in order to get paid, the general contractor is requiring that the subcontractor return a signed and executed version of the subcontract. And at that point, again, the question is, what is the contract between these parties? If we're looking at it purely in a sterile legal environment, right, we have the GC making an offer. We have the sub who rejected that offer and put back a counter offer. GC didn't accept the counter offer, but now the sub has started work. And so we're going to have to look again at conduct to see what is the agreement here. And ultimately, does the sub decide to sign back that subcontract that they got from the GC? And what does that mean, maybe prospectively as they continue to work on the project, as well as for the work that was already done? What were the pressures to sign the contract at that point? Were they fair? Did the sub have any other choice but to sign it? So obviously there's a lot of facts that would shape this dispute, but we do see it happen pretty frequently. Another thing we see happen is that a general contractor will issue a subcontract to a sub. The sub and the GC might exchange some emails back and forth on what the contract quote means, but no one ever makes those changes on the document themselves. Maybe they end up signing it and then they start work. We see this a lot where someone will come in and say, well, wait a minute, I have this email where the GC told me not to worry about that clause, or told me, don't worry, we'll figure that out later. It's not important right now. And you just went ahead and started work. And there's reasons to do that, right? These are business decisions and nothing is just a legally sterile environment, but it's a question, right? Those conversations that went back and forth and whatever the GC said or the project manager said or the super said or whoever, it never got put into the party's contract. And so now we're looking at what was signed, what was agreed to by the parties, and what does our conduct show that we agreed to. Another example that we see come up quite a bit is the GC issues a subcontract. The subcontract refers to or incorporates the prime contract. The subcontractor never gets a copy of the prime contract, whether it be they never requested it, maybe they requested it but never got it, maybe the sub refused to give it to them. There's a whole litany of reasons that this could happen. But when this does happen, we go back to the question of, does the sub know what's in the contract? Does the sub know what they've agreed to, even though they didn't see the prime contract? And I think generally you should assume that it is going to be presumed that you did agree to it. And so this is just a scenario that we see come up quite a bit, and can't emphasize enough the importance of making sure that when we're signing those contracts and we're executing them and agreeing to them, we know what the prime contract is flowing down into our contract. And we'll talk about that a little bit more in a minute. Another example we're seeing come up as well is that the general contractor and the sub will sign a contract. The contract might require the sub to use some sort of project management software program, whether it be Textura or otherwise. And that program ends up forcing the sub to do things that aren't written in the contract, right? So let's say there's nothing in the contract that says in order to get final payment, you're going to have to sign an unconditional lien waiver. But when you go into Textura, it's requiring you to do that. And what do? Because you can't submit for it without signing it, right? And so we're seeing examples where software programs or project management programs are actually trying to insert additional terms that the parties didn't agree to in their contracts. Some of these are thoughts that we've heard repeated, and I don't know how many of these would ring true for any of you, or if you would agree or disagree with them. But I think that there's some good questions and good things to think about for yourself, and ultimately come to some sort of landing internally about these topics, right? So don't risk more than you can afford. Obviously, it's not my place to say when you shouldn't follow this. There could be business opportunities that you decide are worth putting this thought to the side for. But generally speaking, when we're looking at contracts, maybe that's a good idea to follow. Don't risk a lot for a little. And I think that some of this is hard to always know what's a lot and what's a little when you're looking at contracts, right? You really got to understand what the provision is saying, what risk you're taking on, and get to a place where you're able to say, what is that risk worth to me? What do I need for myself and for my company to make that risk worth taking on? And so being able, I think, just to evaluate what's a lot and what's a little is a huge win. And then know the odds. And that, I think, kind of falls into that same one that I stated before, which is if you're able in your contract negotiations to get to a place where you walk away from a contract negotiation or signing a contract where you really feel secure that you understood the document and you understood what risk you took on and what risk you pushed on to another party, that's a great place to be, right? Because from that point, you can start to plan and you can start to know, I took on this risk, I did not take on this risk, right? And so even just that place, I think, is where we hope that you can get. I say all that to say we're also very aware of the fact that a lot of our clients feel, you know what? That's all great, Amanda. Thank you for all those tips. And in a real world, in an ideal world, I would love to do that. But the reality of the world that I live in is a lot of the times I don't feel that I can negotiate contracts. Anytime that I've tried, I send them my changes and it just gets shut down. And then the next person is willing to take it. Right. And so a lot of people come to us and say, you know what? I don't feel that I'm able to negotiate my contracts. And to a certain extent, that could be true in certain circumstances. I'm not going to pretend that it isn't. But I don't think you should be discouraged from trying. I don't think you should be discouraged from getting to that place I just talked about of understanding what the contract actually says and what you're actually taking on as risk and potential reward. And so I don't know if I'm able to hear anyone or talk, if anyone's able to talk, but some of the questions I always like to pose to you all, just so that we know, is what clauses are you most successful in negotiating? Are there things that you are able to get a lot of the times and things that you're never able to change or feel you're never able to change? Is it common that you're promised things in email that never make it into the contract? Do people tell you on the other side what certain things mean, or to not worry about other things? And ultimately, do you feel like you understand the contracts that you sign? Or is it a lot of the times you maybe feel like you understand 50% of it? And that's not to say that there's anything about you that is preventing you from understanding it. A lot of the times these contracts, unless you live and breathe in them and know the legal framework in which they're going to be enforced or not enforced, it's impossible to understand them, right? It's impossible to know what's going to happen with them later on in a court setting. And so these are just questions that I like to hear people's thoughts on and get feedback from you all on these different things. And so I don't know if I can stop sharing for a second to see if anyone has any thoughts on that. All right, I will go ahead and keep going. So I talked about this a little bit, but this is something that I think we all want to be reminded of. Let's make sure you guys can see that. So something to be reminded of: what could starting work mean when you're in the middle of a contract negotiation? Some of the scenarios that I brought forward before talked about this a little bit, but we've seen contracts that tie your starting of work to certain things, right? So if you start work, the contract might say that by doing that, you are warranting the plans and specs. Sometimes we'll see contracts that say if you start work, you're agreeing that these site conditions are suitable for whatever project you're taking on. Contracts might say that if you start work, you're accepting all of these contract terms as is, or that you're representing that you have the proper insurance coverage for whatever you're about to start. And most of the time, most contracts are going to say that if it's a enforceable contract, that any of your prior agreements or conversations, again, are no longer binding. The only thing that's binding now is the contract itself. And so when you're thinking about the question of, okay, we haven't finished these contract negotiations, but I'm being asked to start work, take a look back through your contract and make sure you understand what you starting work on that project without finishing the contract negotiations could mean in terms of later being enforced against you. Let's see. All right. Some of the other things that we see come up often is that there is what appears to be a contract that's been signed by both parties. Both parties agree to it, but at the end of the day, there's been some dispute that's come up. And one of the parties wants to say, okay, there is this written agreement or there is this contract, but how do I get out of it, right? Or why is it not enforceable? And so some of the most common ways that we see this argument get made is someone might say, I was fraudulently induced into signing that contract, or I signed that contract under what's referred to as duress. Sometimes we'll also see that people will say and that there was some mutual mistake of fact about a material term of the contract that both parties had at the time, and so the contract should be rescinded. There was also a concept of cardinal change where people would say, well, I went in agreeing to build one building, and halfway through the project, they issued me, there was a change order that added 5 buildings. And so the scope of this project changed so fundamentally that we should treat this situation as if the contract doesn't govern, because the way the law looks at it is that this material change or this cardinal change was so great that it's almost treated as if it's a material breach of the contract to issue that change. And therefore, we're looking at things more on an unjust enrichment basis, or as if the contract terms don't govern that cardinal change. And so these are just some things to be mindful of, that even if you think you have a contract, these types of defenses can still come up later on if you do end up in any sort of litigation. The other concept I referred to, and you've probably heard of, is a concept of unjust enrichment. So if you are in a breach of contract lawsuit, a lot of the times you're going to see that there's going to be a claim for the breach of the contract. And then underneath in the alternative, it's going to say, well, if there is no contract, then I'm also bringing a claim for unjust enrichment. And so these are what unjust enrichment means. So at the plaintiff's expense, defendant received a benefit under circumstances that would make it unjust for the defendant to retain the benefit without paying the plaintiff for what the plaintiff provided. And so this legal claim it's an equitable claim, and it requires that there be no contract in order for it to be brought. But even if there ends up being no contract, or the court finds no contract ever existed, just know that there's still legal theories out there, mainly in the form of unjust enrichment, that you might see come at you, or you might be asserting to try to get paid back for work that was done. So we've talked a little bit about contract formation, and I said that another part of this presentation was going to be, well, what's included in the contract? And we're just going to go over some high-level concepts here, just because what's included in every contract could take us a very long time to go through. A lot of the times we get the question, or we get clients who walk in and say, here's the contract, or what I think the contract is, here's the exhibits, and we take a look at it and walk through it. And the end of the conversation ends up with a question of, did I really agree to that? Or what did I agree to in this contract? And that's no fault of anyone. It's just because contracts, in the way that they're written, and big companies that spend years and years refining their contracts, make it confusing on purpose, right? And so a lot of the times we get, what did I agree to? And so there's things that within a contract, I think, are particularly worth noting when you're starting your reviews and starting your negotiations. Who are you contracting with? This is something that I think gets overlooked sometimes. A lot of people will come in and say, I am going to enter into a contract with X, Y, and Z company, which is some big company, and they're reputable, and they're known, and we know that they're financially sound, or we assume they are. But then the contract comes to them, and at the bottom, the party signing isn't who you thought you were contracting with, right? Suddenly it's now a single purpose LLC that you know absolutely nothing about. You don't know the financial resources. You don't know the management structure. And so when you're looking at your contracts, one of the first things to make sure you know is, who am I contracting with? Who's going to be putting their signature down at the bottom? And what do I know about that person who's signing it? What do I know about them as an entity? What do I know about the people managing them? And what do I know about their purpose? Are they going to just dissolve at the end of this project and no longer exist? Those are all things that I would encourage you to get in the practice of just looking at whenever you're looking at a contract or negotiating a contract. This one doesn't come up quite as much, but making sure that you know that the person signing the contract on the other side has the authority to do that. A lot of the times contracts are going to take care of this themselves, and there's going to be some clause in the contract that says that both parties do warrant that they have the ability and the authority to enter into the agreement on behalf of whoever they're signing on behalf of. But it's just something to make sure, especially in, like, for example, maybe an owner's rep situation or a construction manager situation, make sure you know that the person who's executing things like the contract or change orders has the authority to do that. And that can sometimes be a harder thing to do than I can say, because you're a lot of the times not going to be privy to the agreements that maybe an owner's rep or construction manager has with the owner. And so it's just very important that your contract reflects in there that both parties agree that they have the authority to enter into that contract. The other thing that we'll talk a little bit about or more about in a minute is flow down and pass through clauses. And I think that this is one of the most important things maybe that you can take away from this whole presentation is just, as subs, it's just so important that when we're getting our contracts and we're seeing the way that the contract defines contract documents, we're taking the time and going through the effort to make sure that we get a copy of that prime contract or whatever exhibit is incorporated into our contract, right? We have to know what it says and we have to know how it affects us. A lot of the times I think people say, well, there's nothing I can do about it. I can't change it. I'm not a party to it. So why do I care? And I get that. But at the end of the day, you're going to be bound by those provisions the same way as if they're in your contract. And so in that framework of just knowing what you're agreeing to, I can't overemphasize how important it is that you're taking the time, going through the effort to get that prime contract. So these are some of the things I hear often is, do I really need to read the prime contract? They never sent me a copy of it, or they never sent me the exhibits. I assumed that that's fine, it exists, but I assume that my contract will trump that. So why read it? And then other times we hear, well, how was I supposed to know that I had to flow down those provisions into my contracts with my subs or my subs? And so again, just making sure we understand that flow down and pass through clauses are as if they're written in your contract, and making sure that you know what they are when you sign it. So generally when we're talking about flow down, we're talking about pass through. The way we're going to think about it is that the contractor has all the same obligations to the subcontractor, all the same obligations to the contractor as the contractor has to the owner with respect to that subcontractor's scope, right? But we would encourage you that if these things are going to flow down when we're looking at it, make sure that you're not just getting all the obligations, right? Like, make sure that you're also getting any benefits that contractor has in that contractor's contract with the owner. So don't just settle for getting the obligations of the contractor. Push for and make sure that you're also getting those benefits as well. This is just an example, and I highlight this because we see this all the time, right? So this is how a contract is going to say, well, I'm going to define contract documents. And when you see that term and when you see it in there, make sure that you're thinking of that as every one of those documents, even if it's an exhibit, even if I don't have a copy of it currently, it's in my contract. So I need to see it and I need to read it, right? So for this clause, it's saying the contract documents, which constitute the entire agreement between GF and contractor, consist of this contract, the scope of work listed in the general conditions, exhibit A, B, C, D, E, F, G, H, I, J, and all addenda issued prior to and all modifications issued after execution of this contract. That's impossible, right? When you get that and you see that, what this is telling you is, hey, first I got to get copies of all of these different exhibits and make sure that I saw them, which is fine and normal. But then we're seeing, wait a minute, all of the addenda, all the modifications issued to after the execution of this contract are considered contract documents in my contract, right? How are you going to keep track of that? How are you going to know what those are? How are you going to know that they happened, right? And so when you see something like this and you see that your contract documents is defined so broadly like this, I can't emphasize enough how important it is to push back a little bit here, right? Like, you need to know, what are these contract documents? If there are going to be modifications to them, how am I going to know about that? Who's going to tell me about it? Do I have an obligation to reach out and be checking if they've been modified or changed? This would just create so much work and so much uncertainty for you that it's something that I would encourage you to work with or try to negotiate to limit. Other times you see things like this. So the subcontract document is comprised of this subcontract, including all exhibits, all written modification amendments, minor changes and change orders to this subcontract, and the design build contract to the extent it does not conflict with this subcontract. So here, again, a little bit more manageable, right? So we know it's going to be our exhibits and attachments, which we are going to ask for copies of and make sure we know what they are. It's going to be written modification, amendments, minor changes, and change orders to this subcontract. So we should be aware of what's going on there. And then also we're going to want to see that prime contract to see where it conflicts or doesn't conflict with our agreement. Just another example, I point this one out because you can see here in 3.2, you're going to see that there's things like where any provisions of the documents incorporated by reference into this trade contractor agreement is inconsistent with any provision of this standard form agreement. This standard form agreement between owner and trade contractor shall govern, right? So our contract should be telling us that if there's a conflict, here's where we should look. Here's the one that's going to trump, and we want to make sure that we're looking for that. Another place that I would encourage you to make sure you don't overlook or go too fast through is definition sections, right? Sometimes our contracts are going to have a whole section of definitions. Other times, it's not going to be contained within the definition section. There's going to be terms throughout the contract that get defined, and you're going to see that parentheses, quotation mark, capital letter, right? And so we need to make sure that we understand how terms are defined and take the time to go through our contracts to, when we're looking at a defined term, to make sure we understand what that means. Because sometimes tricky contracts can make some provision that looks innocent and easy, it can make it actually one of the worst provisions in the contract, depending on how the words within it are defined. And so don't just skip through quickly and not take the time to look at the definitions in your contracts. This is just some practical advice during your negotiations of contracts. We would always encourage you to make a record of those negotiations. Keep your emails, keep your text messages. If there's oral conversations that get recorded on whatever method or project management software or system or papers that you use, make sure you're keeping a record of your negotiations. When you're talking about scopes of work and anything that gets attached to a contract, make sure that it actually defines what you land on, what your agreement is, and what you intend to do. Sign the contract documents and know what they are before you start your work. And ultimately, when you're negotiating, get to that place where you're able to say, hey, maybe I took on a lot of risk, but I know what that risk is, and I know how I'm going to plan to deal with it to the best that I can in the future. And this is, again, when we're talking about keeping a record of our negotiations and our communications, just remember that those communications and emails and oral representations that we get from project managers or supers or whoever it may be, those are not part of our contract unless we put them in it, right? So unless we say or we attach it as an exhibit or we make a change, those aren't going to be part of our contract. Now, there's certain circumstances legally where those might come in later on down the road, but I think you should operate under the assumption that those are not part of your contract. And so I think I only have 5 minutes left. I don't know if anyone has any questions or if there's anything I can answer for you before we wrap up. All right. Well, I will just go ahead and skip to the very end here and just say thank you. There is my contact information. If there's any way that I or my firm can help you out, we're here. We do specialize in representing subcontractors. So this is kind of what we do. And it's been a pleasure and an honor to be able to talk to you guys today. So thank you very much for having me.
Thank you, Amanda. Have a good rest of your day.
You too. Thanks.
Bye-bye.